I see it is straight up 12 o'clock. I do see there's still some folks trickling in for attendance. So I'll just get started with a little bit of background. So my name is Lisa Carlson, and for those of you that I have not yet had the pleasure of working with, I am a healthcare attorney in Holland and Hart Boise office. And I've been with the firm for a little over a year now. Before joining Holland and Hart, I was in-house counsel to one of the large hospitals here in town. And today I'm going to be talking about one of the more publicized pieces of healthcare legislation from the 2020 regular session. And this is House Bill 515, or as most of you know it, the Idaho Patient Act. And if you've read any of the many news articles that were circulating around the time that this was being contemplated, this is also referred to as the Malaluka legislation. So if that's what you've tuned in to hear about, you're in the right place. A few other housekeeping items that I will cover before we get started. First, this webinar is being recorded, so if you need to drop off or you want to refer back to anything we cover, a link will be available to the recording on the Holland and Hart website within the next several days. And that's true of most of our webinars, so feel free to peruse and see if there's any other topics that may be of interest to you. We've also made these slides available for you to download. So again, check that website. Second, if you have any questions as I'm going through these topics, please feel free to use the chat feature in WebEx or the Q&A feature to ask your questions. Sometimes I get a little caught up. I'm not the best multitasker, so I may not see your questions as they come in. And we also have a lot to cover. So I'll try to answer some questions at the end, depending on how much time we have left over. But if we run out of time, just know that I will follow up with you directly by email within the next couple of days to answer your questions. So please ask away. And then finally, this webinar is for educational purposes only. If you have questions about the law as it applies to your specific activities or your specific practice, be sure to contact your legal counsel. Okay, so with that, let's get started. So first I want to give you a really brief history of this law for context. So the legislation was actually prompted by a relatively small medical bill that was incurred by an individual, purportedly in the amount of $294. And when this bill remained unpaid, it was referred to a third-party collection company to collect. And as the story goes, the debt collection agency was unable to collect after multiple failed attempts, and that ultimately resulted in the decision to bring a legal action against that individual. The case was, I believe, uncontested, and the court entered a default judgment against the debtor, and that judgment included additional amounts to cover attorney fees and costs that were incurred in the collection efforts. The collection agency then sought to recover from this judgment from the employee through, or from the individual through garnishment of their wages from their employer. And that employer just so happened to be Malaluka, which is why it was dubbed the Malaluka legislation. Because the situation, the garnishment, then prompted Malaluka's CEO, Frank Vandersloot, to become involved in supporting efforts to combat what he and many others consider to be unfair medical debt collection practices. So ultimately, this resulted in the drafting and enactment of the legislation that we have before us that protects or attempts to protect, depending on your opinion, patients from these unfair and aggressive collection efforts. There's a considerable amount of work that went into drafting the legislation with the involvement of multiple stakeholders. The premises were to increase transparency to patients to ensure that they get notice of who rendered medical services to them and how much they owe, to give them time to pay those bills, and then to protect them from aggressive medical debt collection efforts and excessive attorney fees based upon their inability to pay, or maybe their lack of knowledge of the existence of these bills. So in considering the legislation, House and Senate committee members heard unique testimony from many individuals, both for and against the legislation. Opponents have identified some significant gaps in the law that weren't addressed, and that could ultimately lead to some significant confusion and legal challenges. But important to providers, it could potentially lead to some limitations on their ability to collect unpaid medical bills. Ultimately, though, the legislators acknowledged that the proposed bill wasn't perfect and elected to proceed anyway, acknowledging that they would most likely need to make future modifications to the law in order to address and correct any of those imperfections. So with that, it passed both houses and was signed into law on March 16th of this year. It has an effective date of January 21st, 2021, which is coming up here relatively quickly. And it will be codified at Idaho Code 48301. Okay, so what most of you probably want to know right away is, does this law apply to me? Because if not, I'm sure you have much better things to do with your lunch hour than to listen to me drone on. So let's get into the nitty-gritty details of the law. Consistent with one of the basic premises, which is to protect patients from aggressive collection actions, it's important to understand that compliance with this act is required where healthcare facilities or healthcare providers want to engage in certain collection activities against a patient. So in this first slide, you'll see that I've identified defined terms that are used throughout the statute. These are important. I've bolded them and I underline them so that you can know when I'm referring to a defined term. So essentially, the law applies to healthcare providers. A healthcare provider includes a physician or any other licensed healthcare practitioner, and it also includes a healthcare facility. Healthcare facility is a defined term. It includes any person, entity, or institution operating a physical or virtual location that holds itself out as providing healthcare services. And healthcare services then is also a defined term as services for diagnosis, prevention, treatment, care, or relief of a health condition, illness, or injury, or disease. So in sum, the Idaho Patient Act applies to healthcare providers, and it imposes requirements that must be met before they or their agents engage in extraordinary collection actions, which you'll see at the top there, another defined term. So what is an extraordinary collection action? Good question. On this slide, I have included the actual statutory language of what constitutes an extraordinary collection action. It's a lot of text. I'm not going to read through it. This is why we make the slides available. Also, you can consult with the statute. But ultimately, an extraordinary collection action is one of three things. It's using a collection agency, it's making an adverse report to a credit bureau, or it's initiating legal action, like suing a patient. So for those providers who have no intention of ever pursuing an extraordinary collection action, do you have to comply? Well, the statute specifically states that a healthcare provider is not restricted from demanding or collecting payment for the principal amount that is owed. That means other than extraordinary collection actions. This means that a provider can still engage in their regular attempts to collect outstanding bills, such as sending repeat statements, reminder letters, phone calls, or even potentially imposing reasonable limits on future care. Of course, that depends on the type of care and your patient relationship. So there's other considerations there. But certainly those are other avenues that are available outside the scope of an extraordinary collection action that are not impacted by this law. So it's probably fair to say that most providers don't want to sue their patients or send them to collections, but sometimes reporting somebody or reporting them to a collection agency or referring the debt to a collection agency, these more aggressive tactics are necessary in order to recover the outstanding balance, especially if the amount at issue is significant. So the Idaho Patient Act requires that before a provider can pursue an extraordinary collection action, they have to satisfy very specific requirements. And these requirements follow somewhat of a timeline approach, which is how I've tried to break them down and simplify them here. So I've broken the process into 3 primary steps. The first one being shown here, which is to submit to insurance. This first step is premised upon the date that the patient receives goods or services. So you'll see in that first picture, day 1 or maybe day 0, the patient receives goods or services from a healthcare facility. So it's the date that they receive those goods or services or the date that they are discharged from a healthcare facility, whichever is later. Based upon this date, any healthcare provider that provided goods or services to the patient and who will be billing the patient must begin the claim submission process to the third-party payer that's been identified by the patient within 45 days. Again, you'll see another defined term. Third-party payer includes a health carrier or self-funded plan. So basically, this means you must submit a claim within 45 days to the patient's health insurance carrier that they've identified. And that must be within 45 days of the date that the goods or services were rendered or discharged. Now, if the patient doesn't have insurance or doesn't provide insurance information, then the healthcare provider would submit the charges directly to the patient and the same time frame would apply. So regardless, you're submitting either to that third-party payer or you're submitting to the patient. Now, there are several nuances to this. It seems simple, but there's some nuances here. And so, first, in situations where the patient is receiving a series of medical treatments, the clock starts on the date that the series is complete. And this is something that was contemplated during the hearings. I think they used the example of neuropsych evaluations, suggesting that the billing for that doesn't usually get initiated until the patient completes the series, the final set in the series of evaluations. And it was confirmed that the intent there is that the clock would not start to run until the final session in a series is completed. So second, if a patient provides incorrect information or the claim submission is rejected, it's incomplete, it's incorrect, it can still be corrected outside that 45-day window as long as the claim submission process was initiated within the first 45 days. So you're not going to get penalized for the patient providing you wrong information, or maybe there needs to be, through coordinating with the insurance company, there needs to be a claim modifier added. There's no penalty there. The intent is that you initiate that claim submission, that you don't sit on those claims and not submit them. Third, providers are permitted to rely upon the information given or not given by a patient. So even if a patient doesn't provide information and indicates that they don't have insurance, or maybe they just don't provide insurance information, again, as long as you submit that claim to the patient, then you would be okay. And again, if they submit incorrect information and you come back with a rejection because maybe their insurance, they've switched insurance or their insurance has lapsed, again, not going to be penalized as long as it's within that first 45 days. And fourth, there's a 45-day grace period available if a healthcare provider fails to submit to insurance within that initial 45 days. So the grace period is 45 days, so it gives you a total of 90 days. What this means is that if a healthcare provider satisfies all of the other requirements in the Act, which we'll go over the rest of the requirements later, if you satisfy all of the other requirements except for submitting the claim to insurance within the first 45 days, the provider can still pursue an extraordinary collection action against the patient as long as you submit the claim within 90 days of the date of service. So you have 90 days. There's a little bit of fine print there. The fine print is that by missing that initial 45-day window, the provider or their agent is prohibited from collecting attorney fees or costs. We'll go over those in a later slide, what the attorney fees and costs are and why that's probably not a huge penalty at this point in time. And then number 5 and 6 are tips that I've included to ensure compliance. There's, small tips, but important nonetheless. The first is to build into your process confirmation of insurance information from the patient at every visit. This will ensure that you always have the correct information that you're submitting, have less of the back and forth and having to worry about whether the claim was submitted within the 45-day window. Also will ties nicely into the documentation requirement. So it's important to note that the provider has the burden of proof before they can submit any type of, pursue any type of extraordinary collection action. So documentation in any of these requirements is key to being able to demonstrate compliance and to avoid any penalties that may be imposed on the provider, which again we'll talk about in a bit. So the documentation should include the actual correspondence regarding the claim submission. You should make sure that the correspondence, of course, displays the date it was mailed or otherwise submitted, electronically to that insurance carrier or to the patient themselves if they do not have insurance. So on the next slide, I've tried to simplify and summarize. If the claim submission is between 0 and 45 days, provider can pursue extraordinary collection action and potentially recover fees and costs. Day 46 to 90, just extraordinary collection action, no fees. Day 90 and beyond, no extraordinary collection action is available to the provider at that point. Okay, so that is all I have for step 1. So moving on to step 2. Step 2 is the requirement to send a consolidated summary of services. Similar to step 1, this step is also premised upon the date that the patient receives goods or services or the date they're discharged, whichever is later. And it is the requirement that the patient receive a consolidated summary of services from the healthcare facility where they received services. So this consolidated summary must be received, and I've highlighted that word, receive, and we'll talk about that in a minute because that's important, but it must be received by the patient within 60 days. And you'll notice again another defined term, consolidated summary of services. Can't talk today, sorry. So I'll provide that definition for you on the next slide because it's a hefty one. But essentially, it's been likened to a table of contents of the services provided. Essentially, it's going to be a brief description of what services were provided to the patient, and it includes a list of the independent contracting providers that were involved in the patient's care that will be billing the patient separately. One of the most common questions about this requirement to provide a consolidated summary of services is when it applies and when it doesn't. Because if it doesn't apply, great, you get to skip this step. So at the bottom of the slide, you'll see an exception here. The exception is that the requirement does not apply where all 3 of the bulleted items are met. So essentially, the healthcare facility doesn't have to provide a consolidated summary of services where the patient will only be receiving one single bill for all of the services rendered instead of receiving multiple bills from multiple healthcare providers. So to rely on this exception, you also have to inform the patient in writing of the name, phone number, and address of the billing entity, and then, of course, comply with all of the other statutory elements of the Idaho Patient Act. So as an example of this exception, and this is similar to the example that was used at the legislative committee hearing, so I don't get any points for creativity here, but the example is that the patient goes to a primary care provider. They receive an immunization. The provider is the only one that's going to be billing for services, so the patient will receive a single bill. And the exception would apply because the provider is not, the provider is the only one rendering services. They're not sending out any services for any other provider, so no consolidated summary of services necessary. In contrast, the same patient goes to primary care, but instead of getting an immunization, they get some blood samples taken. Provider takes the samples, sends it to a lab, and the lab receives the sample and is going to submit separately to that patient's insurance for the services that they rendered. But the patient doesn't ever go to a lab. They only go to that one healthcare facility. So for them, it might be surprising when they get a separate bill from the lab for those services, which is exactly the situation that this consolidated summary of services is meant to address. The healthcare facility is required in that situation to send a consolidated summary to the patient, alerting them that they're going to be getting that separate bill from the lab, and that's ultimately the information that will be included on that summary. This helps the patient to recognize that the bill from the lab is legitimate and it does need to be paid. Now, sending a lab sample out is different than making a referral. So it's important to note the distinction. So if you make a referral to a patient for services that they're going to receive elsewhere, like going down the street and getting imaging done for maybe a suspected break, where the patient is going to be receiving those services outside of the medical facility, you would not need to send that consolidated summary of services because they're only receiving services in your facility. So I hope that makes sense. If not, ask questions. Okay, so I promised you a hefty slide with the definition of consolidated summary of services, and here it is. So for those that will have to send a consolidated summary of services, the statute lays out exactly what has to be included. I already mentioned that it's essentially a list of services that were provided and the healthcare providers that provided them, so that patients won't be surprised when they start seeing multiple bills coming into the mail based on one episode of care. So I've included like I mentioned, I've included the exact statutory language on the slide, but it's essentially a summary requires the name and contact information of the patient, the medical office or facility where the patient visited, the date, duration of the visit, a description of the services that were provided to the patient, along with the names and contact information for the entities that may bill the patient separately. And then that statement there, it's circled in red at the bottom, a statement informing the patient that the summary is not a bill. So this language is taken, again, right from the statute. So to avoid any ambiguity, copy paste right onto the top of that consolidated summary of services, and there's no question about compliance. So that makes it easy. You don't have to come up with your own language. Okay, so that covers what must be on the consolidated summary. So again, some more tips and tricks based upon the nuances of this requirement. So first, you can provide this consolidated summary to the patient in person. You can provide it at discharge or at the conclusion of their office visit. and that avoids having to mail it to the patient. But if you go this route, my recommendation is that as part of the process, you build in the requirement that the patient sign confirming that they received the consolidated summary, and then incorporate that signed version as part of the documentation. Number two, you can also provide this consolidated statement to the patient via an electronic communication or through a patient portal, but only if the patient has consented to receiving these types of communications in writing. So that avoids having to mail. Otherwise, as you'll see in number 3, and I mentioned earlier that the word receive was significant. If you mail first class, it must be received by the patient within 60 days. Well, rather just if you provide it anyway, it must be received by the patient within 60 days. But if you mail first class, the statute has a built-in presumption that the statement or that the patient will have received a communication that's mailed by first class mail 3 days after it was mailed. So what this means is you have to actually put it in the mail within 57 days after the date that the goods and services were rendered or that the patient discharged. That way you fall within that presumption that they received it within 60 days. So when you're setting up your mailing schedules, just know that even though it says 60 days, you have to account for that time to mail, and that time to mail is 3 days. So number 4, similar to the grace period that is available for the insurance submission requirement, this requirement also has a grace period. So ordinarily, the provider has 60 days for the patient to receive that consolidated summary. The grace period gives facilities an additional 90 days to comply. So ultimately, that ends up being 5 months total. So again, if you don't comply with that 60-day initial window, noncompliance means that you will not be able to pursue recovery of attorney's fees or costs. You would, as long as you're within that grace period, so you somewhere within that additional 90 days or under the 5 months, you can still pursue an extraordinary collection action. Okay. And number 5 identifies what some consider a major deficiency in this legislation. So in situations where a provider maybe was providing services for or at another healthcare facility, if a provider is left off of that facility or hospital's consolidated summary of services, the provider will be precluded from pursuing an extraordinary collection action unless they work with the facility to reconcile and then resubmit that consolidated summary statement to the patient. So that was one of the reasons that there is an additional 90-day grace period, is to allow for time to correct a consolidated summary that doesn't include the provider. So it's obviously problematic if it doesn't get corrected within 5 months. The provider is unable to pursue an extraordinary collection action, and it's problematic anytime one provider's ability to collect an outstanding debt is premised upon the compliance of another entity. It's really no great solution at this point to that problem, but know that folks are aware that that is a major gap. And then finally, number 6 and 7 are tips for compliance. Again, confirm the patient address at every visit. That helps with ensuring that you're mailing to the correct address, that you've taken those reasonable steps to ensure that you are providing that notice to the patient. And then on number 7, documentation, again, key for being able to demonstrate compliance, which is a prerequisite for being able to pursue collection action under these requirements. Okay. On the next slide. Again, just another quick overview of the timeline. So immediate delivery, you've got 60 days. You've got up to 150 days if you don't go after fees. And if you're mailing, you've got up to 147 days, building in those times for mailing via first-class mail. So I'm not going to spend too much time on that, but that's just a summary for your reference. Okay, moving on to step 3, which is the last requirement. So the last requirement is to send the patient a final statement, which is a bit of a misleading name because this is essentially what most of you would call a first bill. So the patient's receipt of this final statement, again, is premised to be received 3 days after mailing via first-class mail, or immediately if it's sent electronically pursuant to the patient's request. The patient's receipt of this final statement starts the clock for how long the provider is required to wait before they can take additional action. So this is one that's it's a imposition of a waiting period. So once at least 60 days have passed since the patient received the final statement, or the safer way is once 63 days have passed since you've mailed it, the provider can begin to charge interest on the outstanding balance. So the purpose of this waiting period is to allow the patient an opportunity to pay their bill or to contest their bill, to work things out with their insurance company, to set up a payment plan with the provider, maybe to appeal a coverage denial or coverage determination. So again, not to punish the patient by imposing additional fees and interest during that review period. And then once at least 90 days have passed since the patient received the statement, or 93 days after you've mailed it, the provider can then pursue extraordinary collection action. Again, this means provider can use a collection agency, report the debt to a credit bureau, or bring a legal action against the patient. So one thing to note on this requirement is that while the waiting period to commence an extraordinary collection action is generally premised on the patient's receipt of a final statement, the provider must also wait for resolution of any appeals or internal reviews or disputes that may have been initiated by the patient. So if there's an appeal or a dispute pending, you have to wait until that is resolved before you begin imposing interest or pursue an extraordinary collection action. Okay, so the final statement, again, defined term. I've included the exact statutory language here for your reference. The first 2 items you'll see I've italicized. This means it's essentially the same information as what is going to be included on the consolidated summary of services if one was provided. But as you can see, it stops after the first 2 items, which is basically the name and contact information of the patient, and then the name and contact information of the facility where the patient received goods or services. So the third element requires a list of the goods and services the provider rendered, including the initial charges and the date the goods and services were provided in reasonable detail. Reasonable is up to and subject to interpretation. I think it doesn't require extensive detail, but reasonable so that a reasonable person could identify what they're being charged for. Fourth, it requires a statement that a full itemized list of goods and services provided is provided to the patient if they request that list. Fifth is the name of the third-party payers or insurers to which a claim was submitted, including the patient's group and membership numbers. That way the patient will have available to them information about what exactly was submitted to be able to confirm that the correct insurance was involved and the correct numbers, group numbers, especially in situations where maybe insurance might deny a claim, will help them to be able to investigate further. Sixth, a detailed description of all reductions, adjustments, offsets, third-party payer payments, including payments received from the patient that adjust the initial charges for the goods and services provided. So many have asked, how detailed is detailed? And again, good question, and one that the statute doesn't provide much clarity into. So ultimately, it would be up to the discretion of a court if it were ever challenged to decide if a provider had given enough detail. But a good start is an itemization of reductions with a description of the nature of each adjustment. So some have likened this to the explanation of benefits. And finally, most importantly, the patient's obligation. So the final amount that the patient is responsible for paying once you've subtracted off all of the adjustments and all of the other payments that have been made. So that, the final statement is what has many providers concerned about how they're going to be able to provide all of this information, because it's obviously significantly more than what most individuals would expect or have received or have been providing on their final statements in the past. And specifically with the use of electronic medical records or electronic health record vendors, how are you going to get all of this information built into these automated processes so that it's not an arduous and tedious process to be able to provide these? So it can take some significant time. I know there's many different vendors that facilities use, and so it will depend upon the underlying contracts that you may have with your vendor as to whether you're going to incur additional costs with additional build time to be compliant with this law, or whether maybe you can make an argument that maybe there's a contractual provision in there that says they're required to make adjustments to comply with applicable law, and this is an applicable law. But certainly something to consider as you're going through and working with your vendors to automate some of these processes to be compliant and make those necessary changes. Okay, so I've tried to summarize this final step. One thing I didn't mention is that there's no time frame for providing this final statement to the patient. Obviously, it's in your best interest to not sit on outstanding amounts that are owed to a patient and get your accounts up to date. This is really that once the final statement is sent, it starts the waiting period that's applicable to the provider. So again, you have to wait 63 days after mailing to charge interest. You have to wait 93 days after mailing to pursue extraordinary collection action. And then, of course, number 5, because of the amount and type of information that must be included, we recommend, if you haven't already, to, as soon as you can, start working with your vendors to ensure that you can comply with the requirements in those statements that you're sending out to patients. And then finally, I'm just going to say it again, document, because it's really important. Document how and when the final statement was provided. If interest is charged, make sure to document when those fees began, and then, of course, document when extraordinary collection action was initiated. Okay. And again, another summary here for you of just the time frames for waiting depending on how you deliver this final statement to the patient. Okay, so compliance. The entire purpose of all of these requirements is that if a provider complies strictly with these requirements, they will be able to pursue an extraordinary collection action, and they will be entitled to recover fees, which includes attorney's fees and court fees and filing fees, but those fees are subject to statutory caps, which we'll talk about next. If a provider complies with the relaxed requirements, which means that they are within the contemplated grace periods, they can still pursue extraordinary collection action, but will not be allowed to recover fees or costs. And then finally, as I mentioned earlier, the burden of proving compliance with the Act is on the provider. So again, documentation. Good documentation will make the difference between being able to pursue an unpaid debt through one of these extraordinary collection actions or not. Okay, so another major part of the statute is the imposition of a cap on the amount of fees that a provider or the collection agency that's acting on behalf of the provider can collect when they're pursuing these medical claims. So I'm assuming that most of you listening are probably healthcare providers, so you're probably not overly concerned about whether an attorney can collect fees, but you should be. Because just like an unpaid medical provider, no one likes to work for free or for pennies. So where attorneys can't recover fees for the time that they're spending to collect on a provider's unpaid debt, ultimately the cost is going to be passed along back to the providers. So I've broken down the fee and cost limitations into a chart so that you can visualize exactly what the statute requires as far as the different types of cases and the fee limits. So for example, on the first line, I've got the non-contested judgment. And this occurs where a provider or their agent, the collection agency, brings an action against a patient who doesn't fight the claim. And in this situation, the provider wins, and that's a really terrible word, but lack of a better word, the provider wins, so that's your next column. In that case, they can be awarded the principal of the claim that they're suing for, prejudgment interest, and then a capped fee of $350. Now there's an asterisk by the $350 because it's not actually $350, it's $350 or 100% of the principal, whichever is less. So it wouldn't really make much sense to pursue action against cases where you may not even, where it's much less than $350 outstanding principal amount, because it may not make sense once you add in the cost of filing, the cost of service of process, and then of course attorney fees. Let's see. So in the second row, we've got a contested judgment, and that's where basically the patient's going to fight the legal action. In that situation, you can recover, if you win, you could recover principal, prejudgment interest, and then $750. And again, it's $750 or the 100% of the principal, whichever is less. If the patient wins, though, it's very much one-sided. If the provider wins, you're limited on what you can recover, and if the patient wins, they can recover all of their costs, expenses, fees, incurred in contesting the action. Now, this obviously was, somewhat contested. It's not exactly fair at all, but there is a reasonable explanation in that a patient that wins this action would still be subject to the court's determination of reasonable costs and fees. So it doesn't necessarily mean the sky's the limit and that the patient is going to recover a windfall of money. It's still going to be subject to what the court deems as reasonable. It's also important, just for reference and for sort of for additional context, so you understand how little $350 is when it comes to fees. In most jurisdictions, you're going to have at least $200 worth of court filing fees and service of process fees. So and it's typically higher than $200. So I didn't research all of the different jurisdictions and filing fees, but it does eat into a significant amount of that dollar amount that's available to cover both attorney fees and court costs. So it really is not much in the way of money. On that third line, there's some reprieve for actions against debtors that engage in a willful attempt to avoid a bona fide debt. So basically, you've got the medical debtor, they know they owe the money, and they're just going to take every action, every step they can to avoid having to pay. It's a little bit of a difficult burden to prove on the provider, but in that situation, the provider can petition the court for a supplemental award where the costs or fees that they incurred in pursuing this action are grossly disproportionate to the awarded amount. So again, it will be up to the court to grant that award based upon the facts and the fees that were incurred. And then finally, in that last line, this is the one where providers really need to be aware, is that if you pursue an action against a patient where you did not comply with the statutory requirements, the patient can actually be awarded actual damages, including costs and attorney's fees, of or $1,000, whichever is greater. And then if you are found to have willfully or knowingly violated the act, then the court can actually award treble damages, which is 3 times the damages, or $3,000, whichever is greater. So it can get a little bit expensive for a provider that is not compliant, which is why, again, the documentation is so important. Not only does the statute require that you plead with particularity before you even bring a case, but as part of the case, you're going to have the burden of proving that you complied with every single step of the process before you can prevail, even in a non-contested case. So documentation is key. So some final considerations. Beyond mere compliance with the Act, again, documentation. I'm sorry, I feel like a broken record over here. I'm sort of embarrassed at myself for saying that word so much. But yes, it is a prerequisite. Make sure you document. The second one, the cost of filing fees and service fees can take up a large portion of the cap. So it's likely that providers and collection agencies will likely need to renegotiate how they're compensating for collection efforts and if it's worth sending to collections. It's especially true given the increased risk to both the providers and the collection agencies in pursuing these claims where there may not have been strict compliance. It's important also to remember that this act does not prevent providers from engaging in their regular internal collection efforts. It only precludes providers from taking an extraordinary collection action, which, if you are confused, is go to the statute, read exactly what is entailed in a extraordinary collection action. It's quite limited. It's collection agencies. It is reporting adversely to a credit bureau, and it's pursuing legal action. So garnishments, lawsuits, filing a lien against a patient, or seizing their property. So legal action where you're going to have to get an attorney involved to pursue those actions. And then, so as far as your internal collection efforts, you can still engage in all of the same tactics to try and collect on those debts. And then finally, the effective date is slated for January 1st of 2021. And this means that if you look at the very strict, you strictly construe this effective date, it means that any extraordinary collection actions that are initiated after January 1st must have the preliminary steps satisfied prior to the statute's effective date. So if you backtrack, I think that puts you somewhere in the middle of October to where you really need to start complying with this act if you want to be able to pursue extraordinary collection actions after January 1st. Okay, so with that, I provided a few resources. The first one is the most important. It is the code provision. So it currently is not codified with the regular Idaho code because it is not yet in effect, but you can find it by going to this link to the actual bill, House Bill 515. Also, I mentioned the Health Law blog and the Health Law Holland and Hart webinar link in case you have any additional questions or want to listen to more details about this webinar or other webinars, and also the slide deck will be posted at those links. And then finally, thanks to the Idaho Medical Association has agreed to let me make this document that they've prepared available to you. It's a really good resource. It's got information about the Idaho Patient Act in I think maybe it's 2 pages. I think it's 2 pages. Don't quote me on that. A nice resource guide to be able to consult when you have any additional questions. And I am under the impression, or I believe that they are working on an FAQ document as well. So with that, it looks like I have about 9 minutes, and I am embarrassed to say that I have 17 questions, and so there's a lot of questions to go over. I'm definitely not going to get to all of them, but I can certainly pick out a few of the questions. One of them was, are you aware of ongoing legal challenges to this legislation, such as that are coming before the court? No, it's a little ripe for any legal challenges at this point. I am aware that some of the industry groups in Idaho are continuing to work together with the individuals who drafted this legislation. I think the hope is to be able to iron out some of these issues that were overlooked by the legislature as they were sort of in a hurry to get this out in the interest of protecting Idaho patients. So everyone went into this knowing full well that there were going to be wrinkles and that they're going to need to be worked out. So I'm hopeful that with enough feedback that we'll be able to identify these issues and have a law that's actually not overly burdensome to our providers. Let's see. In the event a physician is left off of a hospital summary, is there a time limit for correction outside of which the physician will lose the right to pursue that collection action? That is the additional 90-day grace period. So you've got the 60 days initially, and then you've got an additional 90 days. And then after that, that's the gap. They are precluded from pursuing an extraordinary collection action at that point in time. So again, it's going to be really important that physicians and these healthcare facilities where they're providing services are working together to make sure that no one is precluded from being able to collect their outstanding debts. Good question. What about returned mail? That's a really good question. So I guess there's a presumption then that the patient did not get. That's the rebuttal to the presumption that's provided in the statute. So again, I think that's another gap in the legislation where it's outside the control of the provider if they cannot find this patient. They're using the address that they have on file. They've taken those reasonable steps to be able to confirm address at every single appointment, and yet they still get a returned mail. They now know that they have additional obligation and that the patient is not receiving those notices. So my analysis would be that they would be precluded from pursuing that extraordinary collection action because the presumption would be rebutted. Let's see. There's lot of there's a lot of chatter. So sorry, I'm trying to wade through some of these questions. So confused about non-contested judgment limit and on the amount that can be collected. Can you clarify with examples, please? Okay, so let's go back to this fee and cost chart. So in a non-contested judgment, that is basically when you initiate a suit against an individual. They're served with process. They have an opportunity to respond. They have an opportunity to show up and participate in the proceedings against them, but they do not. So they don't challenge this. So what that means is that the court will enter a default judgment, and the provider will win by default. And in that situation, the fees and costs are capped at $350. In a contested judgment, an example of that would be the patient shows up and they argue until they're blue in the face about how they don't owe this bill, or they paid the bill, or it's an incorrect bill, or they didn't receive the notices, or or the provider is willfully violating the act and harassing them, whatever their argument is. Ultimately, it's going to incur additional fee anytime you have to present, more evidence to rebut what the patient is going to be stating. So it could be that you have to produce more documents, you have to produce more filings, you have to, your attorney is going to be making more motions. You may end up bringing in an expert witness. So in that case, fees can get really expensive really fast. And so that's why there's a different capped amount. So the capped amount in those situations is $750. And if anybody is bored, you can go to the legislative hearings. They have all of the audio recordings of those hearings. And it was really interesting listening to some of the testimony there, because this is one of the more contested items within the law, is these caps, because it does make it very difficult for collection agencies and attorneys to want to assist providers in recovering these amounts, because there's just nothing in it for them, and their fees are very quickly likely to expand much beyond the $350. And I think the contrasting argument was, well, why not leave it up to the court? That seems to work. Let the court decide what is a reasonable fee. But unfortunately, this is how it was passed, and this is how it exists currently. So stay tuned. That might be something that there may change or may not change. Okay, looks like I've got 2 more minutes. And again, like I said, I'll definitely follow up with each of you with your questions after. It's hard for me to read through these and see which ones I might be able to answer quickly. So if you send patients to collections but you don't charge interest, fees, or go to legal, is that considered an extraordinary collection action? Now, again, that is something that is considered an extraordinary collection action. So if you go to the definition of an extraordinary collection action, which I will quickly go back to, you'll see that they have to receive a final statement. You also have to wait those 60 days, and then you can anything that you do before that is going to be an extraordinary collection action. So it's written in a really strange way, but ultimately the way I interpret this is that any third-party person that's collecting on behalf of a provider constitutes an extraordinary collection action and would require compliance with the Idaho Patient Act. So with that being said, I'm going to wrap up, but if you have any questions, I will advance to the last slide. This is my contact information. Please feel free to call or email. I'm happy to help you out. I know this is really confusing. There's a lot of details to this law. So please don't hesitate to reach out, and I will follow up with each of you individually that have provided questions. And with that, I hope you all have a wonderful rest of your afternoon. Thanks.